Now, I wanted to ask you because you wrote a book whose title is in part The Myth of Judicial Activism. So, we've talked about the politicization of the court and the way the general public is, it's not as popular among the general public because some of these decisions are so out of step with general polling. So, why is judicial activism a myth, and is that different than the politicization of the court?
Well, those are great and complicated questions. So my argument in the book was that lots of constitutional questions don't have clear answers. And what happens when the court confronts a question like that is it often has to decide whether it's fair or reasonable to treat people in a certain way, or whether a right is sufficiently important to be protected by the Constitution. And it's not just writing on a blank slate when it addresses that question, because Congress and the president, if you're talking about a federal law, have expressed their view, or a state legislature, if you're talking about a state law, the state legislature and the state governor have expressed their view, right? They pass a law and they're like, we think it's fair to treat women this way, or we think it's appropriate to treat gay people this way. And then the Supreme Court is going to decide ultimately sort of whether or not it agrees with that decision, but primarily, I think, how much weight it's going to give the views of these other government actors, whether it's going to defer to them or not. And if you go through the very complicated doctrine and the tests that the Supreme Court uses, a lot of it boils down to this question: do we defer? Do we trust the judgment of the people whose actions we're reviewing, or do we not? And so the thesis of my book was, you can ask whether the court has a good reason to trust the people, to defer to them, or not. And if there's a good explanation for why it's either said, we trust you, we're going to let you do what you want as long as it's not totally crazy, or when they've said, we don't trust you, we're very suspicious of what you're doing in this area, if there's a good reason for that, it's not activism. If there isn't a good reason, then maybe you could call that activism. And sort of the point of the book was that a lot of the decisions people criticize as activist, like Brown v. Board of Education was one, Obergefell was one, Roe, of course, was one. A lot of those decisions, you can actually tell a pretty good story about why it doesn't make sense to leave that up to the political process. Whereas with a lot of the more recent Supreme Court decisions, I don't think that's true. So I don't think you can tell a very good story as to why judges shouldn't defer to experts about, what level of particulates is safe. That's an area where deference is appropriate. And when judges are like, we're going to make that decision ourselves, that's activism.
That's a very good explanation. And it does, I see how it's different than the partisan politicization arguments, but they are different things. But when you talk about experts, you could argue that the Supreme Court might need to listen to doctors a little bit more than they've been listening to doctors.
You could, and that was actually a big part of the initial Roe opinion. It was not so much grounded in a woman's right to choose as it was in deference to medical expertise. Right? That's Harry Blackman's version. An equality-based argument came along later.